You're watching QTV and I am Mboj. This program is part of a series of programs organized by the National Agency for Legal Aid and UNICEF, and it is part of a child-friendly justice system awareness project in the Gambia. In fact, today this is going to be part 2. Yesterday on Tuesday, we did part 1 in which we talked about the aim of the juvenile system in the Gambia generally. But today we're going to talk about procedures of arrest and detention of alleged child offenders in the Gambia. And I've got here 3 gentlemen to help me chew over some of the issues around our topic today. On my immediate right, I've got here Mr. Modu Sumare. He is a protection officer at the Department of Social Welfare. And on his right, I've got Mr. Samuel Ade, Counsel Samuel Ade, from the National Agency for Legal Aid. And sitting here on my left, as he did the other day, is Mr. Mohammed B. So, State Counsel representing the Gambia Bar Association. Welcome, gentlemen, to the program.
Thank you.
It feels like deja vu. We've been here before. Back. So let's get straight to it. This is about arrest and detention. So first, perhaps we go into meanings. Should I come to the lawyer? We've got here 2. Both of them will help. But what do we mean by arrest and detention?
Arrest, in simple terms, would mean restricting someone's right to liberty and by keeping him in one place as a result of probably commission of an offense or suspicion on commission of an offense, usually by police or state authorities. Now, you would see that under the Constitution, everyone has a right to liberty. So your liberty can only be seized in accordance with the law. And one of the processes in which that can be limited is by way of arrest. And if you're arrested, and your arrest has to be lawful, the lawfulness of that arrest has to be based on either the commission of an offense or the suspicion of commission of an offense by the police.
That's it. And with that one, with arrest and offense, is there any distinction whether you were an adult or a child?
Yes, we will look at, there's obviously a clear distinction between adults and children, and I believe that is the discussion today. So we're going to go in detail.
Absolutely. Mr. Counsel, will you add anything to that?
Yes, if I will add anything to that, is the fact that when it comes to arrest, the laws is very, very clear that anyone can be arrested, notwithstanding whether you are a child or you are an adult or you are of any gender, you can be arrested. But the conditions for arrest are also clearly spelled out. They don't just go generally, because there are specific laws relating to specific categories of persons, and those laws apply based on the circumstances of the case.
Absolutely.
Yes.
And now with the Department of Social Welfare, so where do you come in? Is it that after a child has been arrested, would they call you? How does it work? Where do you come in?
Yes, normally most of the times arrest is done by the police. Of course, like Mr. Sow said, it could be also done by other authorities. But most of the time, if it involves a child, we are always contacted, for the fact that we have a very important role to play. We are always contacted as social workers, and then as a department, we normally respond, to give the necessary support to that particular child and the family. Yes.
Yeah, that's what you do. Absolutely. Yeah. But let me just clear this. I do hear notions like citizen's arrest.
Yes.
Can I do it with a child? How does it work?
Well, our law generally under the Criminal Procedure Code, citizen arrest can be effected, which is that a citizen who's not a police, well, let me not say not a police officer, but any individual who believes that a crime is committed by another or a crime is about to be committed, you can arrest the individual, but hand him or her to the police for the police to take the proper measure. So it means you cannot detain the individual. Rather what you do is hand him over to the authorities, because they have the rightful means of dealing with the individual. When it comes to children, I would also believe that a child can be arrested when he or she commits an offense, but must be handed over to the police as soon as possible. So it's not a matter of delaying the time in keeping the child for that period of time. But what is advisable is that once the individual is arrested, hand over the person to the police as soon as possible. Although we've recently seen occasions where people would arrest, let's say, thieves and have them beaten, but that's unlawful. Once you suspect that someone has committed an offense, hand over the individual to the police as soon as possible.
Absolutely. You've actually touched on the next question. I'll go to Councillor Ade. The circumstances in which one can arrest generally a child.
The Criminal Procedure Code is very clear. Even the Constitution is clear that upon reasonable suspicion of someone having committed an offense or about to commit an offense, these two circumstances warrant that anyone being a citizen can arrest that person. But as my learned colleague has explained, when a private citizen arrests a person, even a child, the law requires that he hands over that child within the shortest possible time possible, which means he cannot detain the child. Now, when we talk about arrest of children, every normal citizen, a normal citizen or a police officer or a judicial officer can arrest a child. But when that child has been suspected, when there is a complaint lodged at the police station that the child has committed an offense, then only those in the Department of Welfare at the police, because the Children's Act has actually created a department at the police for welfare, child welfare department. Only those are mandated to now go out to arrest that child. A uniformed police officer who is not in that department does not have that power to go out and arrest that child for various reasons. One, because children are protected by the law. They are a category of people who are very, very vulnerable and sensitive to anything. So those who have been trained within the police force to work in that Department of Welfare have been trained on how to handle children, even the arrest of children. They're the ones who now will go out based on the complaint to arrest that child. But if there is no complaint and someone sees a child in the process of committing an offense, that individual can, of course, arrest the child and bring it over to the police station.
So there is only that reasonableness test.
Yes.
If you have reasonable suspicion, as it were, then you can do it.
A reasonable suspicion of someone having committed or about to commit. But there is also the process where you find someone in the commission of the offense.
Absolutely.
You have the right to arrest a person as a good citizen.
Good. So, so now you've been informed.
Yes.
The child has been arrested. You go over, or you could be part of the team that would go to do the arresting, isn't it? That was what you said. So what is the procedure? What do you do from there?
Yes, so yeah, usually when a child is arrested, once we are informed, in the soonest time possible, we try to be present. We'll assign somebody to, work with the authorities concerned, if it is at the police, because children, by virtue of their age and maturity, needs guidance. Like my landed brother said, they need some special protection, as it is guaranteed by the Act. Okay, so that is why we need to be there, including also notify the parents. The parents also has to be present before any interrogation or interview is done to the child, so that at the end of the day, those people also will make sure the best interest of the child, is protected throughout the process. Because children, like I said, maybe once they are arrested, probably that could be their first time facing an authority. That fear could be there. Do you understand? So if a particular officer has to interview them without the presence of social welfare or the gender, the parents, sometimes, it could, the child, because of fear or that kind of anxiety, could sometimes, implicate him or herself. So that is why our presence is very important. We will always try to give them the information they need, what is the right of the child and the family, and then also guide them through the process.
Absolutely so. But I wonder though, imagine where you try to get in contact with the parents or guardians, but you've not been able to do so. What do you do? When
yes.
such circumstances.
It does happen sometimes.
What does the department do?
Yes, it does happen. Sometimes that may be the case. We may not be able to identify the family. You know, especially sometimes some of these children on the move. It's very difficult. It takes a lot of time before we will be able to trace the family. You know, but you know, as a department, you know, we are trained to work with those kind of children. You know, we work with the authorities and then try to make sure those guys, we have a temporal place at the shelter where we could place them and then work with the police and then, you know, also trying to work, you know, along to get the family, because the family is very, very important. Okay, but nonetheless, in the absence of the family, we also try to represent the best interest of the child.
Absolutely. I think that's what I was looking for, shelter.
Shelter.
Yes. Counsel, now I'll start calling you all counsel. Counsel So. Yes. I mean, to arrest is one thing, but the procedure.
Yeah.
Yes. What is the procedure, really?
So the first thing, when a police officer or a child welfare officer is giving information or complaint that a particular child has committed an offense or the individual is brought to the police station, the first thing that he or she should do is to ensure that the social welfare officer is contacted as soon as practicable. The parents or guardians of the child is also contacted. The child must also be informed for the reasons for his or her arrest, and also the parents will be informed. And this is closely connected to the constitutional principle that once you arrest someone, you must inform them of the reason of their for arresting the individual. Another requirement that the police are also expected to do, they are not supposed to talk to the child or to interview him for the purpose of gauging what actually happened without the presence of the parents, a social welfare officer, although that can be exempted where the presence of either the parents or the social welfare officer is not in the best interest of the child. That determination is obviously subject to the discretion of the police officer. And again, another requirement that the Children's Act has outlined is that if it is an offense which is not very serious, we're looking at, let's say, theft, petty crimes, right? The child should be released as soon as possible. So he or she should not be kept in detention for that period of time. So the objective always is let the best interest of the child comes first, and which is if he's releasing him to the society is not going to cause any harm to himself or to the society, he should be given bail as soon as possible.
So it is very interesting there. You really cannot take a statement. We all know when we go to the police station, the first thing they do is take a statement. You cannot take a statement with a child without the presence, of a social welfare worker
or the parents,
and the parents and the guardians. Very, very interesting. Counsel Samuel, unless you want to add something else to that, then after the arrest, then what's the next step?
Permit me to add a little flesh to what my learned counsel has said. The process of arrest means that you actually touch the body of the person and restrain him. Or say, okay, you are under arrest. Can we now go to the station? And the person will walk freely. If those processes are not followed, then arrest has not been effected. That is the law. Secondly, the moment you arrest someone, you must tell the person by using the word, you are under arrest. And if you don't do that, it can be taken to be an abduction or a kidnapping, because the person doesn't know for what reason he is being held, he is being restrained. But once you tell the person you are under arrest, the person knows that he is now being arrested by the police. And it is his right to be told immediately, as counsel has emphasized, the reason for the arrest. The Constitution of the Gambia stipulates that at the maximum, within 3 hours, the person must know the reason for his arrest, even a child. Now, what happens when that child has been arrested? It's at the police station. My brother here and counsel has expounded on a lot of those issues. I will just add a few more. The issue of the best interest of the child, it is not a procedure. It is a concept that aims to protect the child against all harm. Even talking violently or rudely to the child is considered as harm under the International Convention of the Child. So making sure that the child is comfortable making sure that the child does not come in contact with uniformed police officers, making sure that the child is not kept in a place where he is with adults, even behind the counter, making sure that the child has food to eat and water to drink. Because if you don't give those facilities to the child, it can tantamount to what is called torture. So, as I explained, the issue of the phrase best interest of the child is a concept that embodies a lot of things that go towards the welfare of the child.
Absolutely.
Yes.
Go
Going forward, after arrest, the police, according to the Children's Act of the Gambia 2005, has the powers, as my colleague has rightly said, to inquire at first instance into the case and see whether they can grant the child bail. The police also has the powers to initiate processes of amicable settlement and reconciliation. It's only in very serious situation wherein the police can decide to initiate criminal proceedings or legal proceedings. Everything regarding the child should, at first instance, end at the level of the police, unless very serious offenses like murder and rape, that the police will now consider whether we should go to the magistrate. Even then, if the police officer cannot take that child to the magistrate before 72 hours, the police have the discretion to consider releasing the child on bail, not to keep the child in the detention facility of the police. That is what the law says.
Absolutely. So this 72 hours also applies to children.
Exceptionally.
That's it. So perhaps one was thinking that, because here we're talking about the best interest of the child, is that a good thing for the police to have that power of retaining you, holding you for 72 hours?
I use the word exceptionally for a good reason.
Okay, meaning
that when the police realizes that releasing that child to the general public will cause harm to the child, then they can keep the child. That also goes to the best interest of the child, because you not expose the child to other activities that do not go to his best interests.
Absolutely. We'll get on to the conditions under which they can detain, as it were, children. I mean, I saw you earlier wanting to come in. What was your comment?
Yes, I think he touches part of that, what I wanted to say regarding the after the arrest. Usually one important element that the social worker also will do is to do an assessment on that particular child. You know, that could be just an immediate assessment to know what the child might need and that particular time, which might include some of the things he said, like the water, the physical well-being of the child, the health, and so on, and then also also sometimes even the environment. Sometimes all those things need to be assessed, and that could also help in giving a recommendation for consideration to the police as to why the child, what circumstances has led the child to such a situation, so that at the end of the day, decisions could be taken based in the best interest of the child. Because at times, usually when the reason why they might have committed a crime or they found themselves in such an undesirable situation is as a result of certain external factors. That is why the assessment is very important in order to be able to help the police in making a decision that will be able to able to serve the best interest of the child.
Absolutely. Yeah. So we go on now generally to the conditions of detention, and who decides? I can just imagine perhaps the social worker may have one view of the situation, the police perhaps have another view, because where you have different actors, the potential for disagreement. Yeah. In the end, really, who decides whether we're going to detain or not? Is there?
That is entirely at the discretion of the police. But like my Leonard Senior said, the police have to consider a lot of factors. I mean, basically it will depend on the circumstances of the case. But they, I mean, obviously the police have to use their discretion, have to use their judgment to determine whether it is even necessary to detain the individual. For crimes like murder, rape, maybe those considerations may be there, probably because these are serious offenses, and usually they attract public attention, and the possibility of releasing that child to the public may be harmful, because some people may want to, we know it in the Gambian society, people always want to do mob justice and all that. So in that instance, it is necessary that the child is kept away by the police. Obviously, we do not expect that the child should be kept in detention, and if the police do not have the facility at a particular police station, probably they can liaise with the Department of Social Welfare, where the child may be placed at the Child Protection Center, pending the trial of the child. That is possible. But just to answer the question, the police decide. But obviously, it's also expected that the police would consider any report that is prepared by social welfare, so that they take that into account when reaching a decision as to whether to release or to detain a particular child.
Yes, Councillor, if I may add, you mentioned something in passing, which to me I consider to be very, very important. The report from the Department of Child Welfare, that is a determinant factor in deciding whether the police will detain the child or not. That report should help the police to come to that decision. The report normally will include alternatives of detention other than the police cell. If the child has relatives who are willing, who are not in that particular community where the offense was actually alleged to have been committed, who are willing to accommodate the child, then that report will indicate that. Because the report is not just done in the vacuum. The Department of Welfare will normally make investigations about the residence of the child, whether he's going to school, he's in the boarding school, the circumstances surrounding his growth and upbringing, and whether they are people, apart from the child welfare center that can keep him, whether there are other alternatives to permit him to maybe continue going to school or learn whatever trade he was learning, best interest of the child. So the report that my Leonard Vodale said in passing is very important. To me, is the determining factor, not even the police. To me, it is the determining factor on whether the child should be kept in detention or not.
Absolutely.
Because the presumption of innocence
goes in favor of the child.
Still goes in favor of the child. He still remains a suspect.
Yes.
Yeah.
But one wonders, in a situation where it is decided by the police that the offense is sufficiently serious for them to go to court, then how does the law treat the child? Would you be treated as an adult? Because there is a serious offense, maybe murder, and you have to go to court. How does it work when the cases are severe like that?
Let me start from this angle. The moment a child is arrested, apart from the Department of Child Welfare that is notified, the magistrate of the children's court is supposed to be immediately notified of the arrest of a child, such that if the police cannot give the child bail, then they should immediately take that child before the magistrate, for the magistrate to decide to give bail. And the same principle applies to the magistrate, unless it is shown that it is not for the best interest of the child for him to be released on bail. He should and must be released on bail, no matter the offense.
No matter the offense?
No matter the offense.
That's an interesting one. So it's either the police or the magistrate.
Yes.
These are the only two.
Yes, they both have the powers.
They all have the powers to do that.
The defining line is that even when the magistrate decides, has a means of last resort, which means after exploiting every available avenue where that child could stay, apart from the detention center or a remand center, and makes that decision must be recorded down And the child must be informed of his right to appeal that decision at the superior court. That would be the high court at first instance. So you see the protection that is given at every level.
Yeah, absolutely. And in the situation, in our scenario here, now imagine the child is supposed to go to court. The Department of Social Welfare, what do you do then?
Yes, the department works with the child throughout, throughout the case, from the time the child is arrested to the time the child is taken to court, until an order is given or not, until the time that the child is reunited back to the family. We work with the child throughout. Once the matter is taken to court, we have our social workers that also visit the court on weekly basis and attend all the court sittings. So usually those social workers will work closely with the child, you understand, and then the assessment continue from, once he is arrested, once the child is arrested, there's an initial assessment done. If the child is now taken to court, that is where the other assessment will be done. This one will be more comprehensive, because this will require sometimes to even, follow the networks of the child, like conducting a home visit, to write a social inquiry report for the court, so that at the end of the day, like he was saying, the assessment will include all the, environmental factors, surrounding the life of that particular child, the educational background, the family, the income, they understand, the other networks of the child, like the environment, the peers, and so on, so that at the end of the day, the social worker will be able to write a comprehensive report for the court, for the children's court, so that at the end of the day, they will be able to understand, the child and the circumstances in which, the circumstance that has led the child to commit, that offense. This will help the court at the end of the day to be able to rely on that report, to make a judgment for that particular child.
Absolutely.
That is why the report has to be very comprehensive. And the social worker will have to also consider what will be in the best interest of the child and recommend that to the court.
Absolutely.
And the court rely heavily on that for judgment. Yes.
And legal aid, automatic for children, is it?
It's automatic.
Automatic, yes.
Once you are below 18 years, it's automatic.
Once you're below 18 years, it's automatic. So now, what next? What are some of the bottlenecks? Because generally we want to institute this into the child-friendly judicial system. So how far have we gone in instituting these policies?
I think we've gone far in terms of having, especially in the police now. I think almost all police stations have what you call child welfare unit, which is a requirement under the Children's Act, which is every police station must have a gender and child welfare unit that will be dealing with issues relating to sexual and gender-based violence, child issues. So these units are in place. But of course, the challenges are there, which is that this unit would need, obviously, trainings have been conducted for them, but more is needed. They needed facilities, such as printers, computers, just to make their work easy, because we're living in a society where, challenges are always financial. So these are issues. If it is fixed on the side of the police, that would also help a lot in the juvenile criminal justice system. Again, for me, I don't think only that unit should be trained. I think every police officer should be trained in terms of affairs of children, because it may be that in a police station you may have only one welfare officer or two. What happens in an instance when they are not present or when they are not at work? What happens when a child is brought to the police station? So for me, as far as I'm concerned, there is a need for more training to be done for every police officer to be au fait with affairs of children. Now, moving on to, before the presentation of the case to court, sometimes we have delays in the system. It may be that the case may not be presented to court on time by the prosecutors, or the court's docket is full, because imagine having only one children's court for the whole of Kanifing, or a children's court for the whole of Brikama. Or some instances, I remember there was a time in Basse. I mean, we went to Basse. One of the panel members was not around, so we had to come back home. So those challenges are there. I think we need more courts, just to tackle the number of backlog of cases that the children court has. So I'm sure there are efforts to that end by the judiciary, but more effort is needed, and I think it's doable.
That's it, isn't it? That's the point. Perhaps because of the institutional shortcomings. So sometimes we may not achieve the principle, the best interest of the child. Isn't it? Sometimes they have this institution.
I like the way you are liking that concept. It's a beautiful concept.
Yeah.
If I'm permitted to make this addition on an issue which I think just slipped in the cracks, the maximum period for detention of a child is 6 months. And detention does not actually mean the child is kept at the police station. Detention can be anywhere. Even in an uncle's house, under close supervision, that will still be called detention because it's an order. It's based on an order.
That's it. But I just want to, that point you first made, the maximum time you can keep is 6 months.
It's 6 months. For the most grievous of offenses.
All right.
For the most grievous of offenses. The Children's Act also talks about 3 months. Now, the problem we face, now we talk about institutions. We have children who are kept in detention for more than 6 months. And the question we are asking is, how did this happen? I want to appreciate my colleague there. I've had a few instances that we have dealt with cases of children who have outlived, or their period of detention had expired. And he was very ready to advise the court to let them go immediately because they had no business being under detention. I've had a few occasions to train even social welfare workers and prison authorities. And I had this to tell them. They have a responsibility to make sure that they keep reviewing all the remand warrants that are there. Because no court in its right mind will ask for a child to be kept in detention for more than 6 months. Maximum, they will even say 2 months, pending the preferment of charges at the level of the higher court for cases which the child is involved with an adult. And the child is kept there in perpetuity. It is the failure of 2 categories of people, the police officers and the prison officers. Because if the prison officers, they review those remand warrants, they will discover that this person is no longer supposed to be here. And they have no business to keep the person there. Their responsibility then is to take the person to the judge or magistrate that send the child there. Then look, oh, the time for us to keep this person has elapsed. We cannot continue to keep him illegally. So you decide what you want to do with him. Set him free, because the prison officers also cannot just release him out of prison without an order. Yeah. And that is not done. And that is where legal aid comes in. We carry out activities. We are actually human resource constrained. We're supposed to be doing this periodically, almost every week, but we cannot do it because of the bulk of cases that we have. But when we do realize these situations, then we approach the courts, asking for the unconditional release of that child.
That is quite interesting, because we've been sort of seeing recently certain interested parties, be it civil society organizations, taking certain government agencies to task going to court. I wonder here, can a private individual do that? Imagine that I know that, for instance, I've got a cousin who's a child, is in prison, has been there for more than whatever. What is it that I can do as a private individual when I know of such a situation?
Of course, family members have that right. I mean, under the Constitution, if you look at the chapter 4 on fundamental human rights, if a person believes that his or her rights have been violated, and the action can be brought on his behalf or on his or her behalf by a family member or someone concerned, someone related to the individual, can go to court and seek for the right declaration, and the right court to go to is the High Court. So that framework is already in place. Whether it is exploited, and for recently, some people have exploited that. We've had cases in respect of illegal detentions that came out of the High Court, and the IGP was asked to pay over $60,000 in different cases. So these frameworks are there. Having the framework is one thing, but having to exploit it is another. I know Gambians always have that reservation about challenging some of these things, but it exists in our law. And just to further buttress on the issue of the 6 months, I think this is closely linked. For me, the intention of the act is that cases in respect of children should be heard as quickly as possible. So that is why the detention usually should not exceed 6 months. But Ade will agree with me that it's always difficult. and of course it's difficult. I mean, speaking from a prosecutorial perspective, is one of the difficulties that we face in terms of prosecution in Gambia is getting witnesses. You agree with a witness that tomorrow you come to court and testify. The day before that you call the individual, he'll tell you I'm in Basse, even though they're in June. So there is a lot of delays that comes out of the court. Or one day you go to court, you are told the magistrate is not around. The other day you're gone, the clerk's son is sick. So it's a whole lot of factors that are combined together. So and it's actually defeating the whole purpose of time limits that are set out in the Children's Act.
Absolutely. So that is quite interesting. So I'll push you guys just slightly a bit. Given the social nexus, given some of these norms, I mean, you've been bringing out these things, it's really a court system. Well, perhaps we need that, but it's really a court system the best way of really dealing with children's welfare. I mean, of course it will be part of it, but is that the only part? Perhaps there must be a kind of combo between this court system and some of the social institutional structures, as it were, in how people deal with certain matters. A lot of people don't want to go to court. They want to deal with things the way we do at home, within going to court, the stigma. Oh my God, just tell everybody about court. We all know how we are like.
Certainly
how do we deal with that?
Certainly we can deal with some issues at the family level, but there are certain matters, for example, sexual violence, murder, rape, serious issues of robbery, because now we begin to have certain children involved in robbery, and these are serious offenses. These ones cannot be negotiated at that level, and like Ade said, at the police level, there are certain kind of cases that can be resolved by the police without going to court. But matters that are of a public concern, obviously there's a need to prosecute the individual, let him or her know the mistake that he has made, and he's punished for it. Obviously, the purpose of the punishment is to reform the individual, so that we didn't want to have that child going back to the society and causing harm to the society. Yes, measures, we can explore our social mechanisms that we have, but for certain offenses, we cannot negotiate those ones.
I'm granted. So that's it. So yes.
Let me add something very important, Counsel. The state has a prerogative in prosecuting offenses that are specifically laid out in the penal code. If you infringe a provision of the penal code, the punishment is probably indicated there. The Children's Act has actually watered down that provision by giving the court and the police the powers to be able to settle some kind of offenses, misdemeanors, as it is indicated in the Children's Act, amicably, and look at ways of reconciliation between the parties involved. These are the social mechanisms you are talking about. That is still within the system. But there are certain offenses which require punishment. Punishment not only in the sense that you be locked up, because as my colleague rightly said, the principal purpose of the law first is reformation, then there is deterrent, and then there is punishment. If you can be reformed by being kept in a child welfare institution to serve a sentence, then you would have served a sentence for an offense which you did actually commit. There are other forms of punishment. You could be punished to sweep the streets, 24 Independence Boulevard, every morning or every 2 mornings for 3 months. You could be punished to go and work in a farm. At least at the end of the day, you learn a trade, become a farmer. Yeah, so these are other social institutions which are available. Unfortunately, we don't have such in the Gambia. Yeah. But if I may add, if time permits, that the African Commission on Human and People's Rights, in partnership with OSIWA, Open Society Initiative, have come out with a guideline on the decriminalization of petty crimes, petty offenses, such that what you are proposing, that even if someone has been found guilty of an offense, that person must not be locked up in a cell, in a prison, as punishment for that offense. The document that issued from Osuwa proposed several other means of punishment, like I've indicated here, community labor and other stuff, which are things which I think the government of this beautiful country, the Gambia, can take on board. It will greatly assist, not only in decongesting the prison facilities, which are overstretched at the moment, but also providing alternative means of training to those who maybe by adventure involve themselves in activities which the criminal code has labeled as criminal.
Absolutely, and even clean up our streets as well. I mean, can you imagine if we had community service and all these petty crimes? You send people out there, this place will be spotless.
So, absolutely. I just want to add on to that. Like also, at the level of the department, some cases also, just to reduce the pressure on the courts, we settle some cases. What has to do with normally civil cases, like custody dispute, between an estranged wife and husband, or maybe maintenance, related, cases, child maintenance. Sometimes when there is divorce, you will see there are instances when the father will just leave the children with the mother, who takes all the burden to take care of the children they are feeding and so on. So when such kind of issues arise, they are normally, some of the one of the parties sometimes will come to the office to complain, and we could invite them as we invite both of them, the parties. We discuss it, mediate, and most of the times, they are settled amicably at the office level, rather than having to go with it. It is unless the court is always the last resort. Unless and until we are able to settle it at our level, the matter doesn't reach the court. Yeah, but we normally succeed in resolving a lot of them. Maybe I can say 90% of cases are mostly resolved at the office level, rather than taking them to court. And I think that is helping a lot in reducing the pressure of number of cases at the court, considering the limited number of lawyers, judges, and so on we have, and the limited number of courts we have, especially for children. I think in the country we just have 3, so the department is helping a lot in reducing that number.
Absolutely, but one can only imagine that your Department of Social Welfare, the work will get even harder. When we look at the youth bulge, we know our fertility rate, and what we've been told, the percentage of people under 18 will be so much. But how do you deal with this? Earlier on, we talked about the institutional shortcomings. That means that you cannot, give the best interest, you cannot act in the best interest of the child. What is the strategy with the Department of Social Welfare for the future? The work must get bigger and bigger and bigger, and everybody's complaining about resource constraints and all this. So we'll be selling our children short.
Exactly. I know resources is a big challenge. In fact, especially the human resource is a big challenge. But I think the ministry is, because it's a new one, we are trying hard to expand, in terms of personnel, in terms of our presence in different communities and so on. Like I said the other day, before we were in the regions, and now we are thinking of going through the districts, and we want to keep moving as much as possible. Those are strategies that we are using, and like I said, the community structures that we are establishing, like in the Greater Banjul area, we have the adolescent neighborhood watch groups, that are established by the department. We have the community child protection committees. These are all things that we are doing. And then the other thing is, children are not only, in the child justice administration, children are not just, alleged offenders. They could also be victims. In such kind of cases where they are victims, we do what we call case management. Where the social worker who is assigned to the case, let's say it's an early, is maybe, let's say it's a rape case, for instance. If it is reported to the office, the social worker will be assigned to take care of the case. Who will do an assessment on the child, the family, and so on. And then at the end of the day, based on the assessment, you may come to, you may be able to identify a lot of needs that the child may have. Probably the child may need some psychological support, psychosocial support. The child probably because of the rape may need some medical attention or services. The child maybe because he has, maybe there could be some risks out of the rape, maybe pregnancy as well, or diseases. So at the end of the day, in fact, it's possible that the child also, there will be need to do some investigation to know who is the alleged perpetrator. So that may require a lot of services, and those services cannot be provided by one institution. So the social worker will do what we call a case management, where based on the needs identified, the social worker will be able to identify the institutions that can provide those needs, and then call them for a case conference. They discuss the problem together, they understand, and then find, a solution, a strategy, so that at the end of the day, all the needs of the child, will be provided. The social worker will just have to do what we call, a supervisory role to make sure that, all the services that are needed, like probably the child needs, example, investigation. The police will help in doing in taking the responsibility. The child needs some medical services. The social worker could work with the hospital to make sure those services are provided. The child needs some legal representation, probably to prosecute the offender. NALA and justice will work on that. At the end of the day, the offender could be prosecuted, and then justice would be served, for the child. In fact, sometimes maybe the child will even need an alternative shelter. It's not only our shelter, but like my brother have said, sometimes we look into the family, the extended family. Sometimes the child will tell you, I don't want to go back home. I'll prefer to go to my auntie to stay, because of the situation at home. So we try to exploit all those kind of opportunities just to make sure that the best interest of the child is always, given the required, attention.
Absolutely, yeah. And absolutely, we haven't touched on the fact that children could be victims, as it were. Yeah. How many times have we heard stories where they should be given succor? That's where they are abused. Yeah. That's something really difficult thing for the law.
Yeah, it is. It is. In fact, recently, I personally did a case where it involved a 14-year-old girl who was raped by her own care. Someone she calls a father at home. And this was a serious case because she at the age of 14 she gave birth, and even that was during the trial, and it was serious because psychologically you could see it in her that she cannot handle it, right? And I remember when there were attempts to apply for bail, for rape cases, the law requires the court to ask for the information from the victim, and she said, no, this man has destroyed my life, so bail cannot be granted. So usually when it happens within a close family, or it's caused by someone who is very close to the child, it's very traumatic for the individual, and that is why the law has put up a very harsh punishment for that. When you have a child being abused by his or her relatives, especially in respect of sexual offenses, the maximum punishment is life imprisonment. So of course the law tries as much as possible to provide protection to the child, and of course this is necessary because children are the future. So once that future is destroyed, we no longer have this country. So that is why most judges understand these things, so that when a case is brought to them on rape and the evidence is available, although Nala will always fight to say he's innocent, which is their responsibility. But again, I mean, considerations have to be made. The society has to be protected from people who abuse children, because these are not people that the society needs. It's important that we keep them in jail for the longest period, so that the future is protected.
That's absolutely, isn't it? A child-friendly justice system surely must also mean that people who abuse them are locked up.
Sure.
Definitely. I agree with that 100%. Yes.
We do hear that sometimes in the papers we are told that you don't get that many prosecutions in the courts. So that element, whether it's just a perception or is it the reality, you know, the newspapers, how we can be like sometimes, but you do tend to get a sense that you don't have that many prosecutions in the courts of people who abuse children.
No, we do.
What do you do?
Yeah, we do. In
Good.
fact, I think 2 months ago we had someone convicted for life imprisonment, and before that we had someone convicted for 20 years. So the cases, we have a lot of cases that are ongoing. Unfortunately, most of our court proceedings are not covered by journalists. So that's another issue. But that is something that we also have to work on. I think the media also needs to focus on the courts. But we have cases that where acquittals are also usually acquittals are obtained by NALA, but we also have a lot of conviction. And I can speak for the Ministry of Justice, because recently we've had a gender and sexual based violence unit plus a child's unit. So we're working very hard to ensure that those kind of cases are prosecuted in the best possible manner and in an efficient way, so that we can secure conviction and, of course, at the end of the day, serve justice.
Absolutely, and we're coming towards the end. And Counsel, is there anything that we should have discussed that we haven't?
Just to, I don't know how to put this, the way forward.
Yes.
NALA deals with the bulk of all children's cases in this country that go to court. We're talking about 98% of all children's cases that go to court, not civil cases, criminal cases. And as my then colleague has already said, they now have a child gender-based violence unit and a child unit at the Ministry of Justice. And we look at that institution that defends the defenseless. And we don't have equivalent institutions, then the scale of justice cannot be balanced. Why I appreciate UNICEF for the effort that they are doing, particularly in popularizing the Children's Act of the Gambia, which I consider to be one of the most prolific documents that I have seen. We need a common law system that protects the rights of children. And in giving that information of what is found in that document out to the public to better serve the ends of justice when it comes to alleged child offenders. Less is being done when the cases have gone to court, because there is no one who is there to defend these children. The suggestion I'm trying to bring forward is that if partners of the government and even the government can assist NALA in getting 3 more legal officers who will concentrate primarily on children's court issues, that will go a long way to assist in the administration of the justice system. I'll give an example. We're supposed to have a case yesterday, if I'm not mistaken, at Masankonko. And we did receive notice from the magistrate to be present. Not only one case, I guess there are many cases there. And unfortunately, no one from our office has gone to Masankonko because we don't have the human resource. We have somebody in Basse who is attending all the cases at the High Court in Basse, and that person cannot be in 2 places at the same time. When we are having shortages, even right in Banjul, I tell you how one lawyer that has to go to 3 courts in one day. Yeah, rushing to become Kanifing, then you go to my 7, then you go to Banjul, or any of the 3 routes, and that you do that in one day. So it is it's a constraint. Going forward, if we could have assistance to get more human resource in the office, it will go a long way to assist in the administration of justice.
Absolutely. We've come to the end of the program. Thank you very much, gentlemen. It was quite illuminating, quite elucidating. You elucidated a good number of things that I wasn't even sure about. Viewers, yes, we were just listening to a program organized by the National Agency for Legal Aid and UNICEF. This is part of a project called A Child-Friendly Justice System Awareness in the Gambia. And I had here Mr. Modu Sumare from the Department of Social Welfare, and I had here also Mr. Counsel Samuel Ade from the National Agency for Legal Aid, and representing the Gambia Bar Association, I've got State Counsel Mohamed Bissau. Gentlemen, thank you very much. And viewers, thank you. Until the next time, I am Mamadou Mbouch.